everyone. Thank you for taking the time out to attend this webinar. So what I intend to do is give you a very brief overview of the PDPA, then incorporating the slight additional changes that came into effect 1st February this year. But just bear with me when I go through the slides. Okay, so generally what was the purpose of the PDPA? It is to govern collection, use, disclosure of personal data by organizations that draws a balance between protecting the interests of the individual as well as allowing the organizations that utilize such personal data for their purposes. So the starting off point first is you need to know what type of data is protected by the PDPA. Not all data is covered by the PDPA. And what are your obligations of the organizations in relation to collection of such data? Okay, so essentially organizations that collect data, use any data, or disclose any data is covered by the obligations imposed by the PDPA. The data that is covered is data that is likely to identify the individual, not all data relating to an individual. For example, generic data such as the gender, educational level, sex is not covered by the PDPA because it does not lead to the identification of the individual. In certain cases, in order for you to use, collect, and release such data, you have to establish that the individual has provided consent. And the consent is known as the consent principle. There's also a requirement currently under the PDPA for organizations that are dealing, collecting, or using personal data to appoint a data protection officer who is known as a DPO. The responsibilities of a data protection officer, okay, is to ensure compliance with the PDPA, implement policies and processes for handling personal data. This is specifically with regards to in-house for the organization, like consider a handbook, employee handbook. Consider what kind of security measures are in place to prevent abuse. Consider updating your records, updating your IT, for example, the firewall, to prevent hacking. And it also has to consider training your employees within the organization on recent developments, as well as liaising with the PDPC, which is the government body that enforces the obligations under the PDPA. Recently, there were additional criminal and civil sanctions that have been incorporated with effect 1st February 2021. Essentially, prior to this amendment, any of the organizations that breach the various obligations under the PDPA would be taken to task by PDPC. But now they've extended this where you have employees of any particular organization. If they knowingly, without the authority of the organization, breach the PDPA, not only would the organization in most cases be held liable under the PDPA, but the employee as well in his personal capacity. And it has extended civil proceedings to allow the individuals whose data has been compromised to commence civil proceedings against the organization, which means that where data has been compromised, not only does the organization face criminal penalties from the PDPC, it also faces potential civil liability from being sued by the individual whose data has been compromised. The PDPA has also always created this Do Not Call Registry, which essentially, if you want to do cold call marketings on the phone, there's a requirement that you check whether this number is listed. There's also a requirement about what information you got to provide if you're making a telephone call marketing, who you have to identify yourself with. So you see the DNC obligations, the do not call obligations, requires that you have to check whether the number has been listed to the DNC. And then if you're making a phone call, you provide information who sent or authorized the marketing of the message. You can't conceal the identity of the sender of the marketing message. But however, this is not applicable if, for example, you are a subscriber and you have given clear and unambiguous consent. But the difference between the DNC consent and consent for the PDPA is that for PDPA general data release, the consent can be verbal. Whereas for DNC, it's a specific requirement that the consent has to be in writing. So who is an individual who is protected? Okay, the PDPA defines the individual as a natural person, whether living or deceased. With regards to deceased, there is a protection of 10 years after the person has passed on. His personal data is still protected. It's not the same as a private limited company, although a private limited company under the law is considered a separate living legal entity that can sue and be sued. But the data relating to the private limited company is not protected under the PDPA. Okay, as you can see, personal data that is contained in the record that has been in existence for 100 years doesn't apply. Personal data about a deceased individual who has been dead for more than 10 years, and this business contact information, for example, your information that you print in a business card that you hand out, such information is not covered by PDPA. It also extends to such information that you may have placed on the company website about your individual's particulars, individual's data. Such information is not protected. So, you know, if you, for example, list the qualifications of your CEO, although the qualifications and the CEO may lead to his identification, because it's listed on your web page, is considered business contact information, so it's not covered by the PDPA. So who are the organizations that have to comply with the PDPA? You can see that the definition under the Act is any individual, company, association, business, body of persons, corporate or unincorporated, whether formed, placed or in Singapore, who comply, compile, use, or disseminate personal data which leads to the identification of an individual is covered by the PDPA. So it's a very wide act. The exclusions to comply with the PDPA: any individual acting in a personal or domestic capacity. Domestic here means family relationships. An employee acting in the course of his or her employment with the organization. In such cases, unless the employee knowingly exceeds the authorization and breaches the authorization, generally the employee will not be covered under the PDPA. However, if the employee does cause a breach through his carelessness or negligence, the organization will be taken to task only. The difference now with the amendment is if the employee also arranges for the use of personal data for his own purpose without authority, then in such cases, not only will the organization be taken to task, the employee as well faces criminal and civil sanctions. Public agency, government departments are not covered by PDPA, and any organization that is dealing for and on behalf of a public agency is not covered by the PDPA. So what are the various rules under the PDPA? Essentially, these are very general overview of the various sections. If you see S11 to 12, this means sections 11 to 12 of the Act. So essentially, an organization has to be responsible for personal data in its possession or under its control. So this creates the accountability. If you have any personal data under your possession or control, there is a responsibility for you to ensure safekeeping of such data. There's also a specific requirement under this obligation to appoint a DPO, Data Protection Order Officer, which I've explained earlier. Responsibilities include liaising with the Personal Data Protection Center, coming up with mandates for the employees to be updated on the current rules, ensure that there are sufficient safeguards against unauthorized data compromise. But for smaller organizations, the PDPA realizes it might be a bit too onerous to appoint a DPO. So it recognizes the ability for you to engage outside third-party providers to work as a DPO consultant for an organization. Okay, what is the consent principle? Sections 13 to 17. Organizations are prohibited from collecting, using, or disclosing the individual's personal data unless, essentially, there's a requirement that you obtain consent from the person whose data you're either collating, using, or releasing. Now, consent under the Act is defined as either express consent or inferred, which is known as deemed consent. This also extends to where you purchase data from a data collation business. The data collation business has to ensure that they have the consent of their individuals' data that they safekeep to release to you. The consent principle also incorporates the withdrawal of the consent. It provides a certain mechanism for an individual to be able to withdraw his consent. And once the individual has withdrawn the consent, there is no longer freedom to use his personal data. All right, so the new exceptions to express consent after February 2021, you see, where the consent of the individual is no longer required. This is in addition to the existing exceptions. There are two new exceptions: legitimate interest exception, business improvement section. The business improvement section is the most progressive one now, which gives a very general discretion. Essentially, for the improvement of business purposes, you no longer need to have the consent of the individual. But you have to remember, it has to be legitimately linked to a particular business purpose. All right. Although it's a very wide definition of business improvement section, if you are taken to task and an individual has complained to the PDPC, you will have to justify whether or not the use or release of such personal data was in fact linked to the requirements of a business improvement. These new amendments have also expanded existing legislation where the consent of the individual is not required. Okay, it's made it wider for the research exception and the business asset transaction. For example, business asset transactions where you're going into a merger, you're doing sale of shares between an incoming company, MBOs. All right, so what is considered a legitimate interest exception? Again, these are all just overviews. Consent will not be required where the legitimate interest of the organization and benefit of the public together outweigh any adverse. Okay, so for example, legitimate interest. Classic example would be where you need to disclose the personal data of an individual to safeguard against money laundering or anti-terrorist financing. Okay, essentially because nowadays with the globalization of finances, most organizations are imposed with an anti-money laundering test if they're dealing with funds. So with this new anti-money laundering requirements, they've also expanded the legitimate interest exception, which created a new provision where the consent to release the personal data of an individual is no longer required. If you look at this is the one that I was emphasizing on. This is a major development in terms of free use of personal data. business improvement exception where consent is not required. So you see, it states if the business needs to carry out operational efficiency, service improvements. So this is a very wide definition. If you can classify it under this definition, then the consent of the individual is no longer required. You see, it extends also to develop or enhance products or services of the business. This is also a very wide definition, which allows a lot of free play within the definition, or to know more about the business customers. The research exception, which expanded on the existing. Okay, so in summary, the changes for the use of personal data, you no longer are required to show that it was impractical to contact the individual whom initially had provided the data, because now you want to use the data or release the data. Okay, you can contact the individual whose personal data is used. No need to show linkage of the personal data to the individual is harmful to the individual. Prior, there was a requirement that if you link the data to the individual, identifying the individual, you had to show that it was not harmful to the individual. Whereas now, all you need to show is that it is in the general public interest, which normally applies in research, because the purposes of research is to develop something for the benefit of the general public interest. Okay. Business asset transactions is also a major expansion of the PDPA. It gives a wider definition of what amounts to a business asset transaction to allow use of personal data without obtaining consent. Okay, and it extends the personal data of independent contractors engaged by your organization. So assuming that there's a merger between two separate organizations, the business asset transaction now allows each relative organization to disclose their independent contractors' personal data as well. There's also an expansion of the deemed consent definition with effect February this year. Okay, now it's subdivided into contractual necessity, consent by notification. For contractual necessity, there is also inferred or deemed consent, where individuals provide personal data to an organization in connection with the entry of a contract. He would have consented to the use of such data that he provided at the time of entering into the contract to the organization if it's related to the contract. You see at the bottom, it must be reasonably necessary for the conclusion or performance of the contract. Okay, so let's say, for example, customer purchases a vehicle. He provides his personal particulars in the sale and purchase agreement, and he asks that the seller of the vehicle arrange for hire purchase. In such cases, if the seller of the vehicle provides his personal particulars to a hire purchase company, there is no breach of the PDPA. Then you have deemed consent by notification. This is where you inform an individual, look, we intend to use your personal data. You have an option of opting out. And if you opt out, we shall not be using your personal data. So in other words, they have a right to withdraw their consent by notifying you. This requires an express part on the part of the individual. An individual who has provided his personal data may at any point in time withdraw his consent. All right, and the PDPA then imposes certain obligations, requirements on the organization in order to comply with the request for withdrawal. But at the same time, the PDPA also provides the organization certain grounds to continue using the data. The PDPA imposes a requirement that when you want to obtain the consent of an individual, you have to be very specific in informing the individual for what purpose you are collating his personal data. the requirement is quite strict. You cannot make a general statement about the purpose for which you are collating his data. You have to be specific, because if you're making a very general statement, it can be said that he does not give you his real consent because he has no knowledge of the purpose for which you are collating his data. So if you look at this case, Galaxy Credit and Investments, they requested their customers, this credit finance company requested their customers to provide photographs in the application form. Okay, so the purpose implicit in the request for photograph is for us to be able to identify a debtor. Later on, when the debtor defaulted on payments, the finance company issued a letter of demand to the debtor, but also stuck a copy of the photograph on the letter of demand. Okay, the PDPC felt that this enclosing the photograph of the debtor in a letter of demand addressed to the debtor was not within the purpose, because the implicit purpose was only purely for identification. But if you are sending a letter of demand directly to the debtor, there would be no purpose served in enclosing his own photograph. And in such a case, the credit company was taken to task and penalized by PDPC. The notification principle. What information organization must provide regarding purpose of collecting? This is an extension of the purpose principle. What is the information? So when you're talking about seeking the consent of the individual, not only must you extend or inform him of the purpose, you see here purposes for collection, use and disclosure, and any other purpose for the use of his data. There is also additionally the access and correction principle. In other words, you have to allow an individual the right to access his personal data, and there's an obligation for you to correct personal data within the organization. The Pdpa, however, does provide certain circumstances where access requests by an individual can also be denied. Okay, so you see in red at the bottom, there are certain exceptions that apply to the provision of access to personal data. There is, again, an obligation to correct personal data by organizations. And if the individual submits a request to correct an error or omission, there's an imposed obligation on the organization to consider whether or not such a correction should be made. But generally, in most cases, there is an obligation to comply with the request to correct the information. The only issue is whether or not the request to correct the information correctly comes from that particular individual or someone on behalf, because then the danger is if you accept or you act on the request from someone on behalf of the actual individual, that may be a malicious correction, which then may result in you as an organization breaching the Pdpa. There is also a requirement on an organization to ensure the data that they maintain is accurate. Okay, but it doesn't mean an absolute requirement. If you look at the first sentence, an organization is required to make a reasonable effort. So as long as the organization can show that they've made a reasonable effort in trying to ensure the accuracy of the data, they have satisfied the test imposed by the Pdpa. There is no general duty on an organization to review accuracy of the personal data. However, I would advise that when you are collating the data, you have a notification to the individual who's providing the data to say, please ensure all data provided is accurate. Make sure that the form collating the information is clear, specific details are requested, and there is no miscommunication or confusion such that an individual may misunderstand the form and provide wrong data or inaccurate data. general protection principle, which is the main section invoked when there's a data breach. So this is the one that imposes on all organizations collecting, using, or dealing with personal data. Any organization that's doing business in Singapore, as you have seen earlier in the slide, it may be an individual, it may be a business, it may be a corporation, an individual, private limited company. It imposes a duty on the organization to take reasonable security arrangements. So the question is, what is reasonable security arrangements? So the organization should consider whether you should design, organize its security arrangements to fit the personal data, identify reliable and well-trained person to be responsible for ensuring information security, implement robust policies and procedures for ensuring appropriate levels, be prepared to respond to information security breaches promptly. Now, essentially, these duties A to D should be within the purview of the data protection officer that has been appointed under the PDPA. Organizations are also encouraged to carry out risk assessment exercises. Essentially, the greater the individual's data that you maintain, correspondingly, there is a greater duty, obligation to ensure even more security steps are taken, because it correlates to what is reasonable in the circumstances. For example, if the data not only contains the names and addresses of individuals, but goes on to include financial bank accounts of each individual, then correspondingly, the burden to discharge reasonable security steps goes up higher. So examples of security arrangements by organizations can include requiring employees to be bound by confidentiality obligations in your employment contracts, conducting regular training for the staff, ensuring your hardware and the software against hacking, access controls, and then also perhaps, for example, sending a memo to your staff and also limiting access to the data to certain staff only and requiring password and verification, instead of just allowing every staff member who comes into the organization to have access to personal data. So if you look at this case, courts, their online website just allowed individuals to key in their email addresses, and then they would then be able to access the personal particulars of the individuals. The PDPC says that sometimes email addresses of individuals are very common because it's like a stamp. So, for example, if I were to send you my email, you would have my email address. And if that was the only requirement to access the personal data maintained by courts, it would be easy for you just to repeat my email address, go on to courts, and then you will get my personal data. So the PDPC says that was too lax, and they should have considered an additional requirement of not only having an email address to key in, but a corresponding password, for example, or maybe you can utilize 2FA. Okay, aggravating factors, the emails were widely shared, this as I've explained, subjected the personal data sets to risk of unauthorized disclosure for almost 3 years, and then courts did not display a lack of urgency to rectify the situation. However, mitigating factors means issues that went towards reducing the potential punishment that courts could face. Main one was that there was no evidence to suggest of any actual loss or damage resulting from the incident. And courts took remedial effects to implement measures from recurrent. But at the end of the day, courts were still fined $15,000 to be paid within 30 days, failing which interest would accrue on the fine. The retention limitation principle under the PDPA states that for what period of time can you retain the personal data? Because after a while, if you have taken the personal data for a particular purpose, once that purpose has been served, you are actually under an obligation to contact the individual to release the data back to the individual, seek instructions, or destroy the individual's personal data. Okay, in this case, Interact Private Limited operated online mobile number auction for between 2000 and 2018. Okay, they had engaged a vendor to provide web hosting services for the auction. Okay, after the use of the auction services, the organization did not delete the files after the server was completed. They transferred the data from server A to server B, and after the completion, they left the data on server A. They were held to be in breach of this retention with regards to the leaving the data on server A. In the end, fortunately for this company, the commissioner decided to issue only a warning. What about transfer limitation principle? You see, some organizations in Singapore may have head offices overseas, and then you may then release or provide personal data of the employees in Singapore to your head offices overseas. So this transfer limitation principle talks about what are the obligations imposed, to what extent can you disclose to entities outside of Singapore. And there is now this new mandatory breach notification that came into effect this year as well. Essentially, it says that on the occurrence of certain events, for example, serious breach where an individual is harmed, or a large breach where more than 500 personal data has been compromised, there is an obligation on the organization not only to inform PDPC within 3 days, but also to notify the individual concerned. And there are now new requirements of what has to be included in the notification, and what steps have you taken to remedy, and what happens if you fail to notify PDPC of any recent compromise of personal data. So you see at the bottom of the slide, what is a notifiable data breach? The definition of what is considered a breach requiring notification, time frames for notification, the information to be included in the notification, and how you notify PDPC, and how you notify the affected individuals whose data has been compromised. So in summary, the new mandatory breach notifications requires, as I've stated, 3 days within discovery of the breach, where it's a notifiable data breach, and ensure that the notification includes the requisite information required by the Pdpa. Okay, with regards to the responsibilities of DPO, as I've explained earlier, they include ensuring compliance with the Pdpa, fostering data protection culture, managing personal data protection, liaising and alerting management. Now, with regards to the appointment of a DPO, you have to seriously consider whether you have discharged the duty if you were to appoint a junior staff, because the junior staff may not be able to discharge the duties of a DPO as required under the Act. So normally a DPO has got to be mid to upper management level who is able to carry out the functions under Section 11.3 of the Pdpa. You also have the Personal Data Protection Center, whose function is to resolve disputes between an individual whose data has been compromised and the organization, as well as investigate breaches of the Pdpa. Now, Section 51 Pdpa creates an offense essentially to impede the investigation by officers of the PDPC, not providing them information, preventing them from accessing information, or essentially providing false information. You can see that individuals is up to a fine not exceeding 10,000, imprisonment not exceeding 12 months, or to both. And in any other case, a fine not exceeding 100,000. Okay, and it also provides that for the individuals who suffer loss because of the compromise of his personal data, he can commence civil proceedings to recover compensation from the organization. These are the additional offenses with regards to the employee of the organization who knowingly, without authority of the organization, uses the data. Okay, the requirement here is actual knowledge that he's doing it without the permission of the organization for which he works, or he is reckless, which means that, you know, he doesn't bother, he's careless. Simple terms to use would be that he's careless. The PDPA amendment has also created enhanced financial penalties, but these enhanced financial penalties that has not been gazetted into force yet. Okay, the establishment of the Do Not Call Registry. The registries are kept and maintained by the PDPC. Essentially, these are people who list their numbers to say that I do not wish to receive cold calls, I do not wish to receive marketing phone calls. The DNC's obligations provide, okay, if you want to make cold calls to individuals on their mobile numbers, such persons are required to comply with the following. Okay, check DNC on whether the Singapore number is listed. You got to provide the information on the individual who sent the marketing material. You cannot hide the identity of who is contacting the individual. But again, there is no need if the subscriber has given clear and written consent. But again, like I have emphasized earlier on, the consent here has to be in writing. All right. So at this stage, you see, I've gone through the Does anyone have any questions?
Okay, you guys can leave your questions in the chat box. We'll read them out and have Mr. Christopher to reply to them.
It's the SMS and even email SMS is covered under the DNC, but email, it doesn't register or record email addresses. Yes, you will have to report the matter to PDPC if an employee is found to misuse personal data. There is an obligation provided you fall within the requirements of what is considered a notifiable breach. Okay, then what else do I have? Yeah, 𝗟𝗂𝗯𝘀𝗰𝗿𝗄, you say you have 2 questions. I can't see any questions.
Hi, Christopher.
Yes.
I'm 𝗟𝗂𝗯𝘀𝗰𝗿𝗄. I was trying to type, but I just ask it over the, you know?
Sure, sure.
Okay, first one is I received a parcel through the Lazada thingy. And they have my full name, address, and phone number on the sticker. Is that a breach?
No, for mail addressee, because they're not supposed to have left it outside. Because when you ordered and you provided your personal contact data, there is deemed consent on your part. You see, for the release of data, it's only if it's not there's no consent. But by you ordering the item and providing your details, you are deemed to have consented because you wanted them to deliver the product to yourself.
Yeah, that's all right. But then the thing is, even my phone number is on the sticker, which is so-called public, isn't it?
But you see, the personal data, that is protected is data that would lead to the identification of the individual. So by disclosure of the phone number alone by itself, it will not lead
Full
to
name,
identity.
address, and phone number. It's on the envelope.
No, in such a case, I would say that you can lodge a complaint because I think they're not supposed to include the phone number as well,
Yeah,
especially if
that's
they
right.
leave it out.
Yeah.
Yeah.
Okay. Second question is from an organization point of view. Yeah, you mentioned that you need to have a so-called what is that, compliance officer.
DPO, a data protection officer.
That's compulsory, isn't it?
Yes, yes. As long as you're dealing in data, which almost every entity in Singapore is in that position now.
Yeah, correct. So is there a deadline to be that officer?
No, it's now it's because it's coming to law already.
Right. Okay. Because when I tried to sign up for the certification, I couldn't get a place. So what do I do in those instances?
I mean, in the interim period, I suggest what you can consider doing is farming out to a third-party provider first.
Oh, okay. Okay then, Ken. So the data must be encrypted and everything now when you talk about the security measures and all that.
Correct. Yeah, because I mean, you have to take sufficient reasonable steps to ensure that the data is protected, you see.
Okay, Ken. Thanks a lot, Christopher.
Okay, sure. Just let me take a look at this question from Joyce. HR department only manages staff personal data. How about customer data? Should it be managed by HR or should we appoint someone? Okay, Joyce, essentially, when you talk about this, whether it's your own employees' personal data or your customers' personal data, this is all considered personal data if the data will lead to identification of the individual. So it should be safeguarded under the recommendation of the DPO, but essentially there is no difference whether it's a customer or the employee. Okay? And I mean, it doesn't matter whether the HR department or finance department, I mean, as long as it is managed and the department managing the data has taken reasonably sufficient steps to protect the data so managed.
Sorry, can I just clarify? I'm Joyce here. Okay,
Yeah.
so for my company, we do have something like a customer data that manage, like the sales department manage the customer data. We also have a customer care.
Okay.
So for our side here, because the customer information that we collected is mainly on the corporate information, like the corporate email, all this, right? So
no, Joyce, if it's corporate email, then it falls under the exception of business contact information. But if any of the customer data would lead to identification of the individual whose personal data is not listed on the business or corporate website, then it could potentially be a breach of PDPA.
okay, example, right? This corporate customer use the company name to start a corporate plan, something like like example, company ABC, okay, because of company give me this mobile phone, so he set up the line for the company ABC. So like that, when he registered with us, is it considered a corporate client data or personal data?
Wait, sorry, say again. Okay, you have a customer. A customer gave his mobile number to you.
Yes, correct. But it's billed to company. Example, my number 1234567 okay, it's actually signed under the company name. So, but customer give me. So this information is considered corporate data or personal data?
No, I would classify it as falling under business data because he gave it to you in his capacity as working as an employee of your customer.
Okay. So in the event if he left the organization, then this number, so-called the phone number, will follow him to go as well.
Correct. No, then if the number follows him to go, then I mean honestly, there's no longer any more need for you to retain the data. So this is under the retention principle. Once the purpose for which the person has provided you the information ceases, and your customer will inform you that he's no longer the customer, right? Then you should take immediate steps to delete that personal data.
Yeah, so I'm a bit confused. It's like I'm not so sure because you see, right, the sales department or the customer care department normally will manage those number, like mobile phone number for the corporate client. Okay, so is this considered a corporate data or personal data. Then
While that person is still employed by your customer or your corporate customer, it is still considered business data.
okay.
But once you've been notified that this individual is no longer an employee of your corporate customer, then there's a duty for you to dispose of this personal information.
Yeah, okay. But the concern here is actually, the question here is actually like, because those corporate client data is managed by the sales department or the customer care department.
Okay.
So in this situation, right, will the HR need to be the DPO for this customer data, corporate data as well? Or
Yeah, correct. Yeah. Because the DPO is to ensure overriding within the entire organization that you're going to have updated rules. So, for example, if you were to appoint a DPO, the DPO would send out a circular to the customer care or the sales departments to say something to the effect, please note that any personal particulars of employees of your customers, once you've been notified that these are no longer employees of your customers, you should take immediate steps to delete the personal data.
okay, meaning say that the DPO supposed
To come up with policy that will apply throughout the entire organization, because that is the function of the DPO.
Okay, so in a way that DPO have to educate the people.
Correct. Yeah, exactly.
Okay, I understand. Okay.
We have one last question from.
Okay, honestly, you're not supposed to retain any personal data who are not shortlisted. Unless when you tell them to fill up the form, you say, okay, please note that we may not offer you a job at the moment, but you consent to us retaining your personal details for up to 1 year. Should the need for us to review or another vacancy applies, then it's all right, because then it's deemed to be express consent. Okay?
We have one more last question from Erica. She asked, does DNC this allow overseas calls?
No. This DNC is only applying to making phone numbers to Singapore registered numbers. It doesn't apply to foreign registered numbers. Thank you for spending your time for the webinar during this lunchtime. Thank you everyone for participating.
Hi everyone, thank you for tuning into this webinar. If you have any questions, feel free to drop them in the comment section below. Don't forget to like, share, and subscribe for more webinar replays. See you again. Bye.